So in the Constitution, the Constitution in Article 5, Section 1 tells you who are the judges for the state of Texas. You shall have one Supreme Court, one Court of Appeals, one Court of Criminal Appeals, district courts, county courts, JP courts. These are your judges. That's it. Everything else is legislated. But it lies in the district courts. It doesn't say criminal court, doesn't say civil court, doesn't say family court. It says district courts.
True.
So in Houston, the Harris County, the largest county in the state of Texas, they were all together until they all split up. Now you have a criminal, civil, and a family court in Harris County. But they're all district courts. They all have the same power.
So, and right, I think I know what you're getting at with this.
So the power comes from the Constitution. That's where their authority comes from. So if I report a crime to a family court judge, and they're a district court judge, and that criminal district court judge, they're still magistrates of the state of Texas. They still have the same authority, and that's why many of us have been filing our criminal complaints in with our civil family court cases, because those judges have the same power. Every district court judge has a Superman uniform. Now, some of them don't want to wear their cape, or they limit their practice to only this. No. If you're reporting a crime to a judge, whether it's a family court judge or a criminal court judge, it should weigh the same. And legally, with the authority and the Constitution and the laws, I would say it is. But we're trained to think just go to the criminal courts. But every judge has the same powers. They can all write writs. They can all do capias. They can do warrants.
Right. So I get what you're saying. And like, when the legislation is written, I'm sure they don't probably segment those courts like that. They just apply it to all. The past couple of years, the public has really been aware of there needing to be a bond reform, especially in Houston. There's like 800 murderers walking around on bond in Houston. And so the public has become aware that there needs to be bond reform. Unfortunately, the public isn't aware that child abusers are set free with a warning. So I don't really think the media wants to talk about that. It's a lot more, I'm not sure if I'd say sinister. It's already pretty egregious that, a murderer or someone charged with murder could get like $1,000 bond, or have to come up with $1,000 after alleging to have killed someone. It really starts off with public awareness.
But you're right, public awareness. But I think we can just use the umbrella, and say that it's the judges that aren't educated, right, to make those decisions. I mean, if you knew your job, you knew your capacity, you knew what you could do, other than procedurally, they know what to do. Wake up in the morning, go have coffee, talk to a few attorneys, go put on my robe, get ready to make some hard decisions. Policies and procedures and shit that they've been piling on constitutional rights for years. And that's what I'm just saying. I'm just saying, look, our constitutional rights are fundamental, foundational. Then you have your laws, your statutes, and those can be wrong. You can constitutionally challenge those laws if you believe they're a violation of your fundamental rights. And then you have all these policies and procedures and guidelines and standards and, factors. But down here is foundational. These are the roots to your rights. And they hanging out up here. They're doing all this stuff, and we are reaching all the way down to the foundation of our rights, and we're coming back and we're like, hey, look at this. These are all of our rights, and you can't infringe on them unless you have a compelling state interest. And these judges are like, these are new arguments. Where are these guys coming up with this? Technology, 2025. We're reading all these case laws fairly quick now with the resources that we have. You put Troxel together, CJC. You start putting other parental right case laws together. You put other case laws that deal with civil rights and equality together, and then you make your argument going forward. That's just my opinion.
Yeah. So, eventually someone needs to take this up to the Supreme Court. Then you also have constitutional challenges. My kind of concern with the constitutional challenge form is that it might eventually get thrown in the trash along the way. The good thing about a case and taking it up to the Supreme Court is eventually that case has to get finalized. I'm not sure that my research shows that a constitutional challenge doesn't have to be defended by the Attorney General. Now, if there's enough constitutional challenges about a topic, it would show poorly on the Attorney General to not defend the law.
But okay, so what if you have the Attorney General's own opinion, several opinions?
Now we're talking
to support your argument, because we have that. We have those opinions. So
to use their own words against them, I mean, I know that would make a great constitutional challenge. Now, it wouldn't be the exact same Attorney General because we had a different Attorney General back then, right? And
we have Ken Paxton. He did the opinion in 2019.
Okay.
And
it was Cornyn before that, right?
Yes. John Cornyn, a Texas Attorney General. But now
we're about to have a new one pretty soon.
A new opinion?
No, a new Attorney General.
Oh. Yeah, so Ken Paxton. Yeah, in his opinion, Representative James White asked for the opinion on parental rights. And that's the one that I tell everyone to file into their case, because it says, before you can limit or restrict a parental right, it must meet a compelling state interest. Doesn't say just for terminations. It says when limiting or restricting a parental right.
What about adding that as an exhibit into your case?
I did enter it into my case. I didn't use it at trial because, well, you know what happened? I got arrested. Bailiff beat me up. But I filed my criminal complaint into my family law case. The internal affairs didn't want to take my criminal complaint. The DA says, well, we can't take your criminal complaint because it's got to go through law enforcement.
How long was your case, and then how long did it take to appeal, and then how long did it take to get back your appeal?
I started in 2016. I didn't have really any problems until, I had problems, but I think our case really started smoking was in 2018. And then right now I'm in the appeals court waiting their decision. They didn't respond to what I was appealing. So I'll be at 9 years in September, and in 3 days, I'll be at 1 year from the appeals process. So they said it takes about a year. So I'm waiting on
soon.
Yeah.